Okay. Hey, good afternoon, everybody. And that was the. I'm Dave Tuckman, the president of the chapter. If you know anybody else, closer to the mic, so they can hear you. Can you hear me? Okay. Yeah. Better. Okay. Awesome. And to everybody that's online as well, hello. We're having some trouble with the Amazon Chime account, so we just updated the website with a link that does work, allowing us to record this. So we will record this, we'll share this online along with a copy of the slide deck for anybody that isn't able to attend. I'm just going to go through a couple of house cleaning things real fast, and then we'll hand the microphone over to Neil. Next month's meeting will be here on, I believe it's November 17th. It'll be the third Thursday. It's going to be a collaborative panel-driven meeting with ISACA San Diego, ISSA San Diego, and ISC Squared San Diego.
Come on, connect.
Yeah, and we're still figuring out who some.
I don't want to be connected with you. Disconnect you. Fucking connect you.
Nice.
Come on.
Oh, Jesus, this is going to drive me crazy. Every time somebody joins a bridge, it's going to do this. This is insane.
At least it's not that many participants. God damn it. Fucking computer.
We're unable to hear the room, just in case you guys aren't aware.
Well, it kind of looks like people might be still walking in. The picture is very small.
Okay, my response is insert word here, technology. You know, whatever word you put here is your choice, but. Actually, one thing I will say is at least we'll have to speed through a lot of the legal stuff, so, you know, we'll do that. How are we doing? We back? We're good to go?
Let's double check. Can you hear us now?
I don't know. I can hear you.
I'm looking online.
Somebody chime in online.
Not seeing anything. Yes.
Yeah, we can
Okay,
hear you.
great. Thank you very much. The only thing you missed when it was muted was me talking about myself, so you really didn't miss anything. For those online. For those in the room, they had to endure the pain. So let's go ahead and keep going here and talk about what we're going to be doing today. What we're going to be talking about is essentially I'm going to give you some highlights and we're going to cover some terminology so that people understand some of the aspects, particularly with California. They like being different and they like coming up with their own rules. So then we're going to talk about the proposed regulation and what that actually means. And then lastly, I'm just going to give you an overview of high-art, action plan. What do you do about all this? And through the presentation, we'll talk about a few other things as well. Love interaction, love questions. So if we get through, raise your hand. Dave, if you're online, if somebody comes up with a question,
Yes.
Okay, thank you. Let's go. Okay, so what are the highlights? What's CPRA about? Predominantly, there's some new concepts that come out of this. Not new for people in privacy, but new for the laws in California. And specifically, they're talking more about sensitive information and giving the opportunity for people to opt out of, collection or use of sensitive information. We'll see some more on that. Complicated, privacy invasive advertising. Does anybody actually believe that that actually happens? Really? Come on. Profiling and automated decision making is going to be more regulated with CPRA. Some of the other areas that they bring up or talk about, maybe not directly, or they talk about indirectly, definitely, are vendor management as far as overseeing the vendors you're using for your processing activities or you're using to do something with the data. Data retention, even though they don't specifically spell out data retention, the word retention is in there right along with collection, use, etc. So it's retention is a concept you have to start paying attention to. And then the last thing, it's not directly related to CPRA, it's more about CCPA, the exemption for HR, employee data, and business-to-business data dies at the end of this year. So that's the other kind of nuance that's going on with this. So one of the things I wanted to cover real quick is terminology, so people understand what it is we're talking about, because this law really focuses on personal information. What is personal information? You can read the definition up here, but it's basically any information that can be directly or indirectly related to somebody. Directly related, driver's license number. Indirectly related, it could be a phone number, because you don't know who that phone number belongs to. But, that phone number could be a business phone number that belongs to 100 people in the office. Who knows? Selling. California loved adding this with CCPA, where there's a definition for selling. Everybody here pretty much has a common idea. If I say I'm going to sell something or sell you something, you know what that is. What they added in was this little phrase of other valuable consideration. So what that means is if you do something in trade or you get something of value from, say, a vendor, but you didn't pay them for it, that can be considered a sale. So just so you understand that. And then the new concept they added in with CPRA is this thing of sharing. And when I first saw it, it's like, oh, great, they're going to cover sharing personal information. No. They only address it sharing data in regards to personal information where the business to the third party for cross-reference behavioral advertising or cross-context behavioral advertising. And I was like, oh great, what is that? So I went and said, okay, what is cross-behavioral advertising? Big long definition here. Targeted advertising across businesses. What does that mean? I have a great example. A couple weeks ago, we were at a store, my wife and I. We went in and I registered for a course and I paid, we signed up. I gave him my email address, my date of birth, all this information. And I signed up for the course. We paid with my wife's credit card. The next day on her Facebook account, she was getting all these messages and advertisements for this association that I signed up to take the course with. Not me, her. And why? Because she used her credit card. So that is, in this whole thing, I call it creep factor. That's, we all used to call it creep factor. It was like,
Sure.
I do one thing, but, you go on to Facebook, right? You see, not only is it, your birthday is coming up, but it's going to tell you what your grandmother or your mother-in-law is, shopping for her birthday. So, crazy stuff. So what's all this mean? Let's talk, now we're going to get into law. What does the law really talk about? Individual rights is a key thing. What rights do I have as an individual for what you do, what a business does with my information? When CCPA came out, they had these things about access, portability, opting out of sale of information. Again, remember we talked about sale earlier, what that actually meant. When CPRA came along, it's an addition. It's not replacing one. It's adding on. So we're actually now, we've got not only CCPA, but CPRA. They added rights like rectification, which is mean fixing incorrect information, right? We're going to correct data. The cross-context behavioral advertising, opting out of, sharing, profiling, yes.
Does it change anything in CCPA?
Not really, no.
It
adds on. It's just
It
like,
adds.
hey, let's put another couple pounds on the top of that.
This wasn't enough.
Yes, exactly. And that's kind of how CPRA came about, because long story short, they were doing a ballot measure initially, and they negotiated to get the ballot measure off by implementing CCPA.
I remember.
Yeah, and so the group that was doing it, Alistair McTaggart and all that, after CCPA came out and said, well, you know what? That's not enough. So they did another ballot measure, that passed, and that's what CPRA is now. It grew out of a ballot measure.
Okay.
So yeah, and then so some of the other things, one of the other key things they added was, this idea of impact assessments. And then lastly, obligation to maintain reasonable security. We'll talk about that in a minute too. So to the point of what's different between the two laws, not significantly much as far as who does this apply to, right? You have $25 million in annual revenue. That's global revenue. I know somebody goes, well, is it state or global? It's global. You have 50K of buying, receiving, selling. You have 100K in CPRA. The number went up, but they also included sharing data. So putting the two laws together, basically, if you have 50,000, you've got to deal with everything but sharing. You need to reach that 100,000 to deal with the sharing or the contextual advertising. Yeah, it's kind of like, yeah, it's tiered, exactly that. And then lastly, the other, and these are ors, they're not ands. It could be any one of these things, all right? The last one, 50% of your annual revenue is derived from selling personal information. So those are the qualifications as who does this apply to? I did want to take a moment to talk about impact assessment because this is new. The key thing to know about it's not everybody has to do impact assessments. It's if you've got high risk, significant risk of whatever processing you're doing or whatever information you're dealing, if there's a high risk. Now, the definition, what does that really comes down to? If you are collecting sensitive information, you're at a high risk. If I'm collecting a first name, last name, and email number, email, the risk isn't as significant risk. I mean, it's a risk, but it's not significant to the point where there could be some significant harm or damage to the individual. Here we go. I knew we'd get there eventually. Sensitive information. What is sensitive information? And this is what they've defined it as. You know, because some of these things you're going to look at, you go, common sense, yes, that makes, you know, license number, social security, passport numbers, contents of a consumer's text, mail, or email. That could be interesting. But on some of these others where we don't, you know, racial and ethnic origins, I mean, that is sensitive information. So these are the things that fall into that significant risk. If you're collecting one of these items, you probably fall into that significant risk category. And you may want to look into doing impact assessments of that particular system or process that you're working on. This is where I put in the caveat of, I am not an attorney. I do not play one on TV. I've been around this long enough to know what's going on, but I'm always going to tell you, you need to get legal counsel opinion, okay? I can point you in the direction. You have to have your counsel sign off on it. Whatever you decide to do down the road, they have to sign off on it. You can't go in and say, well, Neil said, and it's like, well, great, you know. I'm not held accountable. I can say anything I want. I don't have a bar license that I have to protect, but I base it off of my years of experience is what I do. This is one of my favorite ones. What is reasonable security? Because you'll see in law, they always say, must have reasonable security. It's not defined. However, in the lovely state of California, back in 2015, 2016, then Attorney General Kamala Harris issued a report. And in that report, the number one recommendation said, basically, you can read it here, but what it says is, you need to implement the top 20 from the CIS controls and that is the minimum necessary. Now, it doesn't say you have to implement all the controls, applicable controls, but the top 20 would be what they define as minimum necessary.
Someone online is
Yeah.
asking if you can, someone online is asking if you can say.
I moved away, didn't I?
To the mic, yeah.
Yeah, okay. Thank you. I'll try to stay here. I'm going to put my hands here like, don't move.
Yeah.
So yeah, the thing to keep in mind is they do have a definition of reasonable security out there. So, you know, if somebody's measuring, well, what is reasonable security? But CIS Internet is one list of controls. All right, there are many controls out there, and they overlap. For those of you that work in audit, you know they overlap. You have the CIS top 20. You've got the ISO 2700. You've got, you know, the what are they? Oh yeah, NIST. You know those people. You know, you have their standards and their framework. So you have these out there. But what they said for California, the minimum is at least implementing those controls. This is the one that everybody's interested in. I know it's kind of small, but you know we're going to cover it anyway. Who? What?
Microphone.
Oh, Mike. Thank you. See, I've got somebody to keep me honest. That's good. These are the exemptions or the exclusions. Who does not have to follow this law? And most of these belong to, you know, so it's amazing that, you know, California public sector, none of the government agencies have to follow this law. Isn't that funny how that happens? Nonprofits. You know, this law is focused on for-profit companies. Now, those are the types of organizations that cover or address. Data. What type of data is covered or not covered or excluded? You know, if your data, for example, I collect first name, last name, you know, the entire gambit of contact information, but then I mask it or I aggregate it. So I say, instead of, I've got all these users in California, I've got their name for it. I say, I've got 50,000, that's what it says, 50,000 California residents. That's not applicable to the law. I got 49,000 residents in San Diego. You're okay there too. So the aggregate data are de-identified. If I've got it masked or you can't tell with the first name, last name, or you know, whatever it happens to be. HIPAA and CMIA, the health regulations. The idea behind that is if I'm adhering to their regulations, I don't have to then also try to adhere to California's privacy law because theirs is adequate. What I'm doing in HIPAA or what I'm doing for the California medical is adequate for the privacy. Regulatory, they include the driver's privacy program, Graham Leach. HIPAA, again, as a covered entity, same for same. So there's a difference. There's the data, and then there's the actual company. So there is kind of like two exemptions there. But the key thing to keep in mind is you might go, well, I'm a GLBA, right? I'm a finance company. I'm covered. I don't have to do anything. Wrong. The GLBA only applies to the data that you're doing your financial work on. It doesn't apply to anything else, like you're collecting, how many people have visited your website, things of that nature. I'm collecting emails, contact information. That's separate.
Marketing.
Yeah, exactly. That's a separate activity, so it's not exempt. My favorite, I threw the tombstones in because end of life. There used to be an exemption for HR, employee data, and then B2B information. That exemption, they didn't do anything to extend it before they recessed in August. So now it becomes law in January, along with CPRA. So I just thought I'd mention that.
So that's one way out.
No, not anymore.
Oh, on January.
January 1st, it's no longer, So a lot of HR people are concerned about this because you think about it, employee data. Look at all remember that list of sensitive information I showed you earlier?
Yeah.
How much of that list does HR collect? So, now we're going to, now they're going to be required to do an impact assessment according to that theory because they're high risk. That's an interpretation. I can interpret it that way. You may meet another attorney that doesn't. I'm just saying I would look at that and go, there's a risk that I could be held accountable for not assessing my HR data. As I said, employee data, so what does that actually mean? So the same rights that we have as individuals now applies to a company and their employee data. Within bounds, there are certain laws and regulations that HR has to adhere to. And they are not going to just arbitrarily give up the information. So, it has to be a balancing act between existing laws and what, can an employee come in and say, you fired me for cause, now delete all my information so that I can then turn around and sue you for firing me, right? That's not going to happen. But hey, trust me, if I thought about it, somebody else there has thought about it. So that happens. Sensitive information, like I said, individual rights, they have the right to delete, correct, and to know. So they have the right to go to HR and say, an employee, I can go to Dexcom and say, what data do you have on me? I want to know what you have. It could be the categories and then, or can I, give me the exact data elements you have. And then regulations apply equally to the employee. Oh, yeah. So the regulations apply to the employee personal information.
Yeah.
This is the one everybody always worried about, right? Penalties. What happens if I get caught, right? That's the thing is, and they got these things in here about, for every violation, it's, maximum civilian $2,500 violation. It's like, well, that's not a lot. That's per violation. So say, for example, you were collecting information on 75,000 people. Let's take that 2,500 and multiply it by 75,000 now. That could be your fine. Same thing with children. Children's even higher, 7,500. Yes?
Would it be as per violation per person or per piece of data?
Usually per person, I would interpret it that way, is by individual. You may have 100 pieces of data on me, but say, for example, the violation is you didn't give me the right to opt out of, limiting my sensitive information. It would be, for me, that's one. And then,
So like the recent Uber breach, think how many people ride in an Uber. Would this apply retroactively?
Well, you can. It depends. I'm not going to, case law, I will comment on case law that's been decided. So, for example, we talked about employee data a few minutes ago. Even before this law comes into place, a few years back, Sony employees sued Sony and won because there was a breach at Sony and their personal information was compromised. They sued and they won. So in those cases, I say, yeah, it gets there. But until they get, because it's like a long drawn out process. And until somebody coughs up the money, I'm not going to comment on what, could happen. But speaking of which, very recently, matter of fact, in August, Sephora paid a fine of $1.2 million for exactly violating the CCPA. In other words, they weren't giving the people visiting their websites an option to not sell their personal information. What was the other thing? They were not informing that they were not informing the individuals they were collecting information on that they were selling that data. Again, think of that selling definition for California. And then thirdly, it was they weren't, somebody would say, I want to opt out. And they ignored it. So 1.2 million for Sephora. This came about not because they sent out like over 100 letters to all these different companies saying, hey, you need to prove to us you're complying with the do not sell. Just something as simple as that. So it was a, what do they call it, sweep, where they got caught up in the sweep. Now I'm sure there's other companies out there that either have not settled or they haven't gotten to that point yet.
I have a question.
Yes.
So the 1.2 million, which is a fine that goes to whatever agency for the violation of the law of CCPA, but that isn't the limit necessarily. So back to your Sony example.
Yeah.
So people from Sephora could also class action suit, right? They have redress through the CCPA.
They will. They do. They have private right of action. That is something that even with CPRA, they've made sure that that's included. Where not only can you be fined, but yes, you can have somebody turn around and sue you. But you have to have, usually with CCPA, there has to be a breach involved in order for that to occur. In other words, it's just, the act of not complying with an opt-out request isn't enough it had to involve a breach where their information was compromised. So that's usually the kind of, the bar they put to it. The new thing that CPRA did was create, guess what? Another government agency. California Privacy Protection Agency. They're another agency that can enforce privacy laws. However, that does not, you still have the Attorney General. The Attorney General will still enforce and prosecute certain laws as well. So just know that there's now 2 sheriffs out there for privacy. Proposed regulation, this is fun. So part of what the agency was supposed to do is develop these rules or regulations. They were supposed to complete it by July. They didn't get there. It's delayed. And as a matter of fact, they're having another meeting tomorrow and Saturday to discuss these rules and regulations we're going to cover here quickly. Because I'm looking at my time, I want to make sure I don't go over. So just know that it's a work in progress.
Oh, you're good on time.
Okay. So it's a work in progress, which means what I tell you today could change tomorrow or Saturday.
Sure.
This is the current structure of the proposed regulations, 9 articles covering different areas. General provisions is there, but it's also, there's a whole section about how you will handle consumer requests. And believe me, there's a lot of detail in there. And there's no way we can get it. I'd have to spend 2 days just explaining all the nuances of these things. But in general, so general provisions really is about collection, use, retention. The information you're collecting, using, or retaining, again, remember I talked about retention earlier? That word is in here a lot. Reasonably accessible, reasonably necessary and proportionate. In other words, you're not just arbitrarily collecting everything in the kitchen sink. You're collecting what you need for whatever purpose you have it for. So for example, at Dexcom, we're a little, we collect patient information. We collect glucose values on a regular basis from our patients via a mobile app. Now, that's necessary for what it is we provide. So that's there. Now, do I need to have the person, because it's a mobile application, do I need their geolocation? No, not for the purposes of what we're doing. So it would be considered unnecessary if I was collecting geolocation. And yes, we all have engineers, developers, and people developing, product out there that want to go, well, give me everything, because I don't know, I might find some use for it down the road. And it's like you have to be careful with that when it comes to personal information. Again, minimum necessary, possible negative impacts. That's the other thing. What harm could you cause if this information were to be compromised? And then additional safeguards. Now I'm going to go off on what we would commonly refer to as a squirrel here and talk about data mapping. Why? Because in order for anybody to comply with all these regulations, all the different rules of privacy and everything like that, you have to know what it is you have. And a lot of companies don't. So this in particular I'm using as what is data mapping? These guides came from the NIST privacy framework. I didn't come up with these on my own. I give credit where credit is due. There's two parts to data mapping. There's collection of inventory of different items, collection of what systems, what data, who are the owners, who owns that system, who's responsible if that system has a problem, who do you go to? What categories, what the flow is of the data and everything. That's the second half. The data flow diagram, that's the second piece. I worked with a gentleman for a couple of years, and he taught me this one, data flow diagramming, and how important it is. Because in order for a company, and this goes beyond privacy, people. It goes way beyond privacy. Everybody could utilize these diagrams because then they understand the processes that are going on. They understand who's involved, because it's not just system owners, by the way. How many people out there are using a cloud service where Google is hosting it, or Microsoft Azure, or what are they responsible for? Everybody's probably, the security people have probably seen the shared responsibility thing, right? Well, what are we responsible for when it comes to processing information? Because again, one of the differences, people think privacy and security are synonymous, and they're not. So security is about preventing unauthorized access, right? We're keeping people out. Privacy is more about what am I doing with the data once I have it, because you will see, like, for example, one of the terms I've seen used by the one of the chairman at the Federal Trade Commission is they commonly refer to things as the misuse or abuse of personal information. They're not saying you can't have it. It's just, what are you doing with it? And that's where privacy comes in. We make sure that whatever you're doing is going to comply with whatever applicable law or laws are out there. So that's kind of the difference between the two. But back to data mapping, what is it? It's like, well, inventories, like I said, data elements in the environment. This is a basic diagram. I'm not saying this is the only kind of diagram you can have. This is a sample so people can see, what do you mean when you talk about a diagram? Here, I got swim lanes. I can identify who's responsible for what activities just by looking at the diagram. So it's those kind of things that, what is it, so the inventories, all the data points, everything about your systems is part of it, and then the diagram is the other. They work together. Yes?
And like you said, this is so invaluable from either a privacy or a security perspective.
Yes, anybody should be able to use it. There's a lot of times people will interchange, again, here we are interchanging. Well, isn't a data flow, is it a system diagram? It can be. A system diagram can fulfill this need for you. It's up to the organization. It's up to the environment you're in. It's like, there is no set, it's, yes, you need to do data mapping. How you do it is up to what your organization is and how you operate. So that's just general. So the next section is disclosures and communicate. Disclosures, I love, that's such a legal word, disclosure. Are you disclosing? What are you giving, what are you telling other people? What information are you giving to other people? Disclosures about. So as far as disclosing, or you need to tell the individuals, notices that shall be easy to read and understandable. And if anybody's ever gone online to a Microsoft and signed up for a product and seen their terms and agreement, is that easy to read and understandable?
Sure.
If you're a lawyer, maybe. But again, that's the type of thing. They're saying, no, your sites, your privacy policies, notices, whatever you want, you call them, have to be understandable to the average person. Oh, let me, before I forget, like the image here at the bottom here, I went online, out on the internet, and I copied a few footers from different companies. And one of the things that is in the regulation right now, they talk about conspicuously, visible, the link. These are, enlarged, by the way.
Right.
Because most of you, if you're looking for security terms and agreement, anything like that, it's in the footer at the bottom of the page, somewhere in there. And these are actual examples from out on companies that have things out there. Oh, that's the other thing I want to recognize. You notice there are one or two of these that they don't say anything about do not sell. That's one thing I neglected to say. If you do not sell, in other words, exchange personal information for any kind of value, you don't have to post a do not sell my personal information out there. As long as you can show or prove that you're not selling the data. Same thing. Same for the new one too, sharing. If you're not sharing for contextual advertising, those types of activities, you don't have to necessarily comply with these. I'm sure there's an attorney that will, could, come out with a different opinion of that. But that's the way I look at it right now. And that's the way I've seen it done, is it states if you don't sell, you don't have to put a link out.
Right.
This is everything that needs to be in your privacy policy, by the way. Policy notice, personally, they call it privacy policy. I look at anything that's on the internet that is posted on a web page as being notice. I think of policy as being an internal document, so don't confuse the two. A lot of times we talk about policy. These are the things, though, that they're looking for that you explain or have outlined in your policy on your website for your customer. There's a section that talks about notices, all the notices you need to give to the customer, right? So the first one there, collection. Everybody's like, wait, I got to do a collection notice? What's a collection notice? One of the most common ones you're going to see or understand about a notice about collection is that infamous cookie banner that pops up when you go to a website. It says, do you want, will you accept all cookies? That's my favorite. That's the only option they give you, right? Either no or accept all cookies. And it's like, that could be questionable as whether or not that's actually true choice, and that's a legal argument. But anyway, that's collection. There's financial incentives. In other words, you have to give somebody notice if you're going to give them something for financial gain, that for them, for the individual, not the company. Opt out, the right to opt out of the sale and sharing. So that's back in CCPA land, they came out with you will have a link that says, do not sell my personal information on the website, right? The right to limit is new with CPRA. That's the add-on in this case. And the right to limit is the right to limit the use of my sensitive personal information. So that list again, let's go back, I need to just have that slide come up every other slide, right? So that list of sensitive information is, I have the right to tell you to limit what you can do with it. You might have it for just, for whatever business purpose you need it for, but I can limit you. And so now we have another link we have to put on our webpage, right? Well, they thought of that. And in the regulation now, we're talking about regulation, the regulations they're writing. They said, well, we have an alternative opt-out link. And what that is, but here's the trick. They specify what that link will say and look like. Literally, what you see on the screen right now, the wording, your privacy choices or your California privacy choices are the words, just like do not sell my information. But the interesting thing here is that icon you see there, the little check and X, they put that in the regulation. That's the icon you need to use.
Oh, seriously? That's
Seriously.
ridiculous. That's ridiculous.
Yes.
Do they do geo-tracking to determine if you're in California?
No. No, this is just, it's one of those things. I mean, could you do geo-tracking? Yes. I mean, IP addresses, everything of that nature, on the back end from a technology standpoint, sure you could. And we'll talk about something similar to that in a minute. But I did want to say, and this is, again, California, it's the first time that I've seen, and I have not seen all laws, so the first time I've seen where the regulatory authority has taken such an in-depth, not only are we telling you need to put a link out there, we're going to tell you what it says and what it looks like, which is a little bit extreme. The word draconian comes to mind, but that's me.
Does this pertain to the business or to the end user?
The business. The business must post this so that if I go to their site, I want to be able, instead of having, do not sell my information, limit my personal, my sensitive personal information, I have one button. So it's ease of use for me as the customer, right? I only have to click one thing. But now they're saying I have to make it look and feel like that.
But if you're not in California, it doesn't make a difference. If you're a customer and you're in Ohio.
Yeah, no, because the rules, yes, they apply to California residents, but from a technology standpoint, if you talk to most engineers trying to implement, all these things based off of locations, one is a technology nightmare. Two, can it be done? Yes. Three, is it going to be accurate? Because I'm on vacation and, I'm going to be on vacation in a couple of weeks over in Caribbean islands, right? And yeah, I'm nice. And I have nothing to do with it. It was my wife. So if I do something over there, it's like, oh, I'm a resident of the Caribbean, but I'm a resident of California. So, there's some pluses and minuses. Can you do it? Yes, but it needs to be thoroughly thought out. I'm not going to say you can't.
It's very scalable.
Yeah.
So these are generic now, your California privacy choices, and that makes the assumption that you're opting out of both?
Yes, that's exactly what the regulation says. And again, it says today. Tomorrow it could change because it was in one section, they moved it. There's a change they did.
So is that CPRA going into effect 2023?
Yep.
Wow.
The regulations are for CCPRA and CCPA. And that's really what we're into here. So this Article 3, I have one slide for, but it's probably takes up most of the 70 or probably 45 pages of regulation. Wow. And I'm sorry, I just cannot spend all the time that they have as to how you will treat all these different requests. I'll give you the highlights. Consumer right requests is what they call it. In GDPR world, I put DSARs, data subject access requests, same thing. What requests are we talking about? Request to delete, request to correct, and request to no. So, then you have opting out, which is not exactly the same thing, but they consider it part of it. So opting out has two designated forms, like that button you just saw. You have to have a toll-free phone number.
Wow.
Oh.
That's what it says. And then if you're an online entity and you have a website where you interact with customers via the web, you have to have an online web form for the same purpose. You do have other alternatives, though. You can use an email address, here, send an email to privacy@acme.com if you want to execute a right. Form on, let's call that again. Oh, yeah, paper. Form on paper, you can actually hand them, or mail. That's the other one, mail. You can mail it to them, so if you want to do it. Those are alternatives. But I will say some of the interpretation, again, this is what I've read. Like I said, if you're an online service, they expect a web form. You can't circumvent it and say, well, we told them to send in a paper form instead. It's like, no, you don't get to do that. That's the interpretation I've heard. It's going to be a case-by-case basis. Timelines for requests. If anybody submits a request, you have 10 days to respond to say, I've gotten your request, confirm the receipt. You have 45 days to comply with it. In other words, if somebody says, I want you to delete all my information, the clock starts ticking, you got 45 days. Now, there is in CCPA, there is, you can another 45-day extension, but I steer clear of that. Yes, when you actually operationalize, you can do that and say, well, I've got planned for 45 days. That way you're pretty much, protected. Michelle, you had just asked about something about, and this is the last item here. They changed the wording a little bit. You notice I crossed out where it said global privacy control. And for those of you old enough and can remember, there used to be this little thing called do not track in web browsers a long time ago. That died an ugly death. But they removed the term privacy, global privacy control. However, they still say opt-out preference signals. In other words, if I've got on my browser the capability to say, I do not want you to sell my information, it's a setting, and I go to your website, you have to be able to read that setting and comply with it, is what they're saying. So it's a technology way of complying or executing an opt-out. Again, regulation could change.
Okay, so if you say opt-out preference signal with the check mark.
Yep. No. It's a back-end signal. Sorry, I'll clarify that for you.
Yeah.
It's not a link on the page, or it's not an icon or anything like that. It's literally, I'm in a browser like Google, or I'm in my browser settings, and there's a privacy controls, and I say, well, I don't know the settings off the top of my head. I go say, I don't want anything shared. The company has to comply with that. Basically, if my browser says don't share anything or don't sell anything, then they're supposed to comply with it. So it's a back-end technology piece. Okay. The rest of the articles aren't as onerous, or they just cover small areas. So hopefully we'll get to service providers and contractors. This is something in CCPA that they defined that, just to remind people, there's a lot of people, you got service parties, contractors, third parties. Not in California. You have service providers who you sign a contract. They're an application, a service, something like that. You have contractors. You sign a contract, and they're working for you. Now we have third parties. Basically, third parties are defined, and we'll talk about them in a sec, is those are the individuals you're dealing with that are taking personal information, but they're, commonly information brokers. Those types of individuals, they don't have any relationship with you directly via contract is the primary thing they're using today. So they're a third party. They're not providing you a service. They're getting you the information. You're required with those service providers and contractors, to cover real quick, is making sure, again, vendor management, making sure that your service providers have proper controls, proper security measures, proper organizational technical measures in place. That's a responsibility of me if I'm hiring a company. So doing, assessments, not necessarily audits, but it depends. If they are like integral to your company, and they, like say, if we were to outsource our CGM process to another company, I would damn well be auditing them.
Sure.
Again, what's the level of risk? You take that into account. We talked about third parties. The regulation specifically says no contract. You don't get to share, collect, use anything with those third parties. So in order for you to share information, you have to have a contract in place. So if you're using something like, say, Google Analytics, I don't think we'll sign contracts for that. We just install it, right? According to them, California, you have to have a contract to do that if they're collecting personal information.
So like any API that's public.
Could be, yeah. They're establishing what the rules are, what the relationship is. So, and you think about it, it kind of makes sense from a protection standpoint. It's just, you're not just arbitrarily sharing information with somebody you're not aware of or not familiar with. You have a relationship established. Verification. Implement a reasonable verification method. Verification being, I submit a request for you to delete all of my information. How do you know it's me? How do we know I'm legit? So there has to be a verification process for something like that. Now, if I've got an account, and it says on here, if I've got an account and I log in with a password protected account, that's enough verification. You know, for me to go then, you know, and say I'm in my account, and if there's an option in there that says, you know, I want to delete my information, I can do it. And I'm already verified because I logged in. As long as I didn't, you know, send my password to a Nigerian prince or something.
Or even if he had it, but you didn't share it.
Well, you know, how many times, I mean, we see this happen all the time. We got people get emails that look legit, says, hey, you need to reset your password.
Yeah, it just went out.
Yeah, and I mean, so that can happen, but, you know, again, the law isn't responsible for that. If a person logs into their account, I'm assuming that they are a valid user. And so I can't, you know, validate every person. You know, oh, they logged in, let's send them a verification. Wouldn't you love that? Get a verification email every time you logged into something? Oh, wait, I do get that.
Pretty much.
I do, on the risk of what am I logging into? You know, a bank, definitely. You know, I'm going to an insurance company, somebody like that. Yeah, they are implementing multi-factor authentication, right? We're going to verify who you are so that you may end up going that route. Again, back to that sensitive information. If the high risk is there, maybe that's a control you want. This piece on age, minors. It's kind of, you know, this is what I love about, you know, when they delineate out what's a minor. You think under 16, no. So there's this wording in the regulation that says, if you have actual knowledge that the person is underage. I'm assuming that means you've somehow verified that they're underage. You've asked them, you know, there's that statement, are you under 18 years of age, right? And of course, all teenagers check, yes, I'm under 18. Yeah, they do. There's, you know, date of birth. Oh, yeah. I was born in 1959, you know. I mean, I can just put anything I want in there. But, you know, again, actual knowledge. It's a wording that, to be honest, might give people a certain out as far as if something were to happen. It's like, well, we had no actual knowledge. But anyway, regardless. So under 13, here's the difference. We were talking all this time about opt-outs. Under 13, opt-in. You have to opt in. There is no opt-out. And this is protection of children, which I totally wholeheartedly
Sure.
and it, you know, reasonable method for parents and guardians to verify. COPA still is in play here. You don't get to go, well, I'm doing this, so I don't have to follow COPA, which is child protection, particularly on the internet. Still applies. It doesn't negate or override. One does not override the other. And then of course they've got between 13 and 16. So under 13, it's the parent and guardian has to opt in. Between 13 and 16 or below 16, the individual, the minor, can opt in. It's still an opt-in, but the minor can do it versus the parent or guardian.
I have a silly question. Why not just do that for everybody?
I refuse to answer for the fear of incriminating myself. No, it's like a lot, you know, okay, this is my opinion. Like a lot of laws, we have people, you know, we all know there's lobbyists out there and everything, and that's what they do with laws is, you know, they get the law in their favor to make it less onerous. And I don't blame them for that. They're a business. They're trying to do business. And, you know, an unwielding law can make it difficult to do business or very costly. So, yeah, we do that. And this is one of those things where it's like, we're still asking for opt-ins for minors. For adults, you're kind of like on your own. And it's an opt-out. You can always opt out. That's the thing that they changed. At least they're required to give you the opportunity to opt out. It's just a proactive action that I need to take versus them doing it or giving them. It's they ask for forgiveness instead of permission. Yep. And let me move on before I get into trouble and say something else I shouldn't say. This is an interesting thing I've always found with CPRA or CCPA and CPRA is there is actually a requirement for training of record much, but training. If you have employees that interact with consumers, they have to understand this. They have to understand what rights the consumer has and be able to explain it to them. If they, the tech support, if I call in the tech support and say, what are my privacy rights? They should be able to explain it, and they should be trained in that. That's in the regulation, not the law, but the regulation is saying train these people. The second part, record keeping. Essentially, particularly when it comes to requests, people go delete my information, give me my any kind of those requests, 24 months, keep the record. But then somebody goes, well, if they ask me to delete all the information and I got a record that I deleted, they've got their name and email, you have to keep it by law. So that's the other thing too. All of these things apply, but if you have a law you have to comply with, you don't get to just wholeheartedly go delete financial records. You have to keep them, 7 years or whatever the financial regulation calls for. So you are allowed to keep records because of law or requirement. So it's just not a wholeheartedly, but that, covers that particular piece. The last, we're at investigate. Oh, this is a whole new section they added to the regulation. It's new, and they're going to be, I guess, discussing it tomorrow and Saturday. And it's the investigation and enforcement, what they can do, what they will do. So sworn complaints, they can come out and file a complaint against you. Yeah, we've discovered you are violating privacy law. We're going to have you. Stipulated final orders. That Sephora that we looked at earlier, that was a settlement. That was, hey, I didn't go to trial. I agreed to settle and pay $1.2 million. Imagine what it costs if you go on the trial. So, it's in lieu of a hearing. I don't want to do the hearing. I'm just going to pay the fine and agree. So you remember, it wasn't just paying the fine, though. They agreed to do certain activities, make sure they comply with opt-outs and all that. So it's more than just paying a fine. Usually you're required to do some additional work. Make sure you have a proper program in place or something along those lines. They're allowed to audit you. They can come out and audit a business, provider, an individual if they want it. They have that authority. Now, they're auditing your privacy practices, your privacy program. That's what they're coming out to audit. I know when people hear audit, they go, oh my God, they're going to see I didn't pay my taxes. No, it's not that kind of audit. And then selection. How are they, if they determine or they find out that your processing activity is a significant risk, that audit becomes a higher probability, okay? Just know that. It's not that, they didn't go out and hire 87,000 agents to do this. It's just, again, it's an agency just getting started up. They're going to go after the low-hanging fruit, like, sure. Sephora's, the Facebook, the big companies. That doesn't let us off the hook, though. Smaller companies, you just don't hear about them. You hear about the big ones. The smaller companies pay too. You just don't hear about it. Nope. So, okay, that's all the regulations and everything like that. That's our quick tour through there. But what the heck do I do about all this? How as an organization are you going to handle this? Some people might be, further down the road here than others. But here's your quick action plan. First, assess. Figure out what it is you've got. What do where are your gaps? It's like it could be something as simple as, do I have a program? Right. I have a privacy policy on my website, and that's it. So what do I need to do to respond to all these requests if I have to respond to the requests? So that's what you need to assess. Do I need to be concerned? Am I in the on somebody's radar with this regulation? Update your inventories. That data mapping we talked about earlier, crucial. And again, like you said, it can benefit the company in more ways than one. Update, review your policies, notices, procedures, all of the documentation. Why does that happen? I always hit mute and it still rings. I'm like, sorry about that. Yeah, rights requests. If you don't have something in place, get it.
We're just going to want to wrap up.
Yeah, okay. And then, so through there, Last thing I'll give you is there is a resource out there. There's an organization, IAPP. They are International Association of Privacy Professionals. They have a, for like, I'm looking for help, right? They just republished their tech vendors report for this year. There's 365 different vendors listed in that report. I think the first one a few years back had like 20. So it's a very popular business these days, privacy, but it's a resource. You can go download it from the site for free. It's available to anybody. But it's, you can at least, it's a starting point if you're looking for help. There's a number, and of course, talk to your friends or peers and whatever, and you can find somebody there.
And that's publicly available. You don't have
You don't need to have an account. You don't need to be a member to get that report. Other things there you do, but that one you don't.
Right.
I know we're at time.
I do have a question. You talk about how they are going to get together tomorrow and Saturday.
Yep.
Who are they?
Oh, so you have the board, and then it's open for what they refer to as public comment. Literally, anybody in this room could go to that meeting. If you sign up, you could actually make comment. A lot of times it's, they're going to give feedback to that regulation that I was just talking about. Right now, with all its edits and everything, is like 72 pages. But things like, remember that global privacy control was crossed out? That was a change from the last one. Now it's just this arbitrary preference signal.
So somebody just posted online that was canceled for this Friday. And
Yeah, the next one will be August 28th.
Yeah, as I said, it's what's the influx? How's that? The regulation, I said at the beginning, it's proposed and it's in flux.
But if nothing were to change, this is what it would be.
Well, the laws are still there, yes, but the actual implementation of the regulations would be hard to do because they haven't officially, they can't enforce what they haven't published yet.
Got it.
So, but I would not count on that because, no, I just wouldn't. It's just prudent to make sure that you're, because this is, if you have nothing, it's not like I can do it in a weekend and it'll be done. No, it's going to take time. Yeah. And you don't wait. I mean, we're in November now, or excuse me, October. So
yeah,
it's not that far away.
Did anybody else have any questions?
Yes, sir.
Yeah, I have a couple questions. One was, under SPI, you mentioned the contents of consumer texts. So does that include, like, if you have your customer service as like a two-way texting?
It can, yeah. Yeah, because it's usually, think of it as personal information in that text. So, for example, years ago, I knew a plastic surgeon that would be basically giving his patients advice on clear text. Not a wise thing to do, but this was, some years ago when everybody was texting everything. So yes, that's where it comes in is, it's what's the think of the content. What is the content on those emails, texts, or whatever?
Okay. And somebody, like a lawyer for a different organization that I work with was trying to sell me on using them for CPRA preparation. He mentioned having a WISP, a written information security plan or program.
Yeah, ISMS. I mean, it's an information security program. Would be just a general, there's a bunch of.
So there's nothing special or new that's.
No, it's a common information security, cybersecurity practice. And that's, again, goes back to best practice, or, what's your cyber hygiene, your cybersecurity hygiene? That would be your foundation.
Are there any U.S. federal laws that are
nope.
all this?
There's wishful thinking about, there's a privacy law, federal privacy law out there. It gets a little bit of hype and it falls back. So it's been doing 2 steps, 1 step back. I know that people say, oh, there's going to be a privacy law soon, but I'm still waiting for the federal cybersecurity law. I haven't seen that one yet either. So, will it happen? It's possible. I mean, crystal ball and all that. I said, yeah, maybe they'll get one eventually. What kind of teeth it has, because one of the biggest sticking points right now in the federal law is you had Nancy Pelosi, she had a hissy fit. And, she just got upset at the fact because the law they're trying to put in place has less stringent or less strength than the California law. And one of the concepts out there about legal is the precedents, and, excuse me, not precedents. Now I'm going to forget the word. Preemption. Preemption. So the idea being federal law trumps federal or state law. So if I have a federal law in place, your state law doesn't count. And there's always legal argument. That's where you go, hey, we're going to Supreme Court. So, you know, those types of things. Sir, I don't know. Time? Okay.
Is GDPR a lot different in all of this?
GDPR is yes and no. It's probably a lot more stringent in some respects. So for example, there are no exclusions in GDPR. There is no such thing as health information from the aspect of I have a separate health law. Everything is treated the same. They require a lot more as far as, for example, impact assessments. I told you it's just high risk, significant. There, basically, if you're doing anything with personal information, you need to do an impact assessment. And that impact assessment, you determine, you know, it's security, privacy controls, all of that. So, yeah, they're a little bit more onerous, and that's what a lot of people, you know, they equate California law to GDPR. It's close, but it's still GDPR wins.
Can I talk you into a presentation maybe next year comparing the two?
Comparing what?
GDPR to CPRA.
Yeah, you can. Well, you can almost put that on a flyer. I mean, we could. I mean, it's a conversation.
It's getting close.
It'd be more interesting. Yeah, it'd be more interesting, I think, if the federal law goes into play and then comparing the two.
Gotcha. Okay.
So,
cool.
you know, but, you know, who knows? We'll see.
Awesome. Does anybody else have any other questions or anything?
Instead of like penalizing a company, like, you know, the risks for tracking now for socially responsibility, do they ever reward a company for doing the right thing? Or make them a poster child, or a positive reinforcement?
I've not heard or seen. It's kind of like, I've never seen them give an attaboy.
But then you could want to maybe do more business with somebody who's responsible with your data.
No, usually what you end up with is that's where the company will go the direction of implementing either a standard or getting audits, certification. So for example, on the security side, you have SOC 2, you have you know, ISO certification, the NIST are guidelines, but there's no certification goes with it. But that is how companies are presenting and showing that they are, you know, they have adequate controls in place for both security and privacy by implementing, you know, putting a, you know, selecting a standard to follow.
And ISO is the first one that's actually provided a standard with a certificate, right? Is the PIMS?
Yeah, there's the PIMS certificate, which is an addendum. It's not a standalone. It actually goes with the security certification. You can't have privacy without the security. You have to have the security certification. So that's a certification, and it's, you know, again, you present it. One of the other ones out there that's proprietary for the medical community, it was for the medical community, but now is trying to expand in other areas, what's known as HITRUST. And HITRUST is these are very onerous programs. They are going to put you through the ringer to make sure you have the controls in place necessary for security and now for privacy.
Dude, that was awesome.
Good. Much more fun when it's not just me talking.
Yeah, no, that was great. Very much appreciated.
Yep.
Okay. Thank you, everybody. See you next month.